Well, hello, everybody. We have Judge Mark Davis here with us tonight. I can't thank you all enough for tuning in. I love this book. I'm not a lawyer. I don't pretend to be a lawyer. Even watching the show sometimes is a little bit over my head. But I feel fortunate to welcome you here. This book is in layman's terms, and it's kind of like a gossip story because you get to know that the principal people that were on the Exum Court, the Warren Court, and it's interesting. I think people have this preconception that people who are judges it's a hand-me-down job. And they're all white men who are rich when they're growing up. And you tell a story about their different lives and men hiding candy in a drawer because their wives were coming in. So it's it's a real read, and you make these people real human. And I really appreciate that. Mark Davis is running right now for tell us what the specific role that you're going for again.
Well, again, Sue, thank you so much for having me. I really am delighted to be here. I am actually running to keep my seat on the Supreme Court as an Associate Justice, which is fun. It usually means traveling around the state, going everywhere. During the pandemic, not as much. So doing a lot of Zoom like everybody else is right now. But It really is a pleasure to talk about this book because writing it truly was a labor of love for me.
Well, you can see that. And I was talking to Heather Bell Adams a little while ago, and she says you are genuinely one of the nicest people you've ever met. And
oh my goodness,
the fact that she said when she was a young intern, you helped her because you wanted her to understand the job. You wanted her to understand, and lift her up. And any assignments or questions, you took the time to answer it thoroughly and completely. And she thanks you immensely for that. And she says hi.
Oh, please tell her hi back. That is so kind of her to say that.
She's also an author and a lawyer and perfect looking. So let's get back to you, Mark, in this book. Judge Davis writes in his foreword about the task it took to shape the law of North Carolina and how it was not a job, but a privilege. And some of your best times were during this time. On January 7th, 2019, the North Carolina Supreme Court celebrated its 200th anniversary, which is wild. So how did you feel being a part of that, 200 years of celebration?
It all came at me at once. I had the honor of being appointed in March of 2019 during the court's 200-year anniversary. So that's how I came to the court. I never knew what it was like to be on the court not during the anniversary celebration. But it really was a special celebration. Normally we have to sit in Raleigh, but we got permission from the legislature to hold court around the state, which was a great experience. And we made it to, I think, 23 counties. And we were hoping to go to a number of additional ones, but then the pandemic hit. And that pretty much got us back in Raleigh doing oral arguments remotely.
North Carolina is huge. I mean, it really is. When you look at all the counties, you don't realize it when you look on a map, but when you drive through it, it's gorgeous. And there's so many different areas and topography and everything. It's just a beautiful, beautiful state and so much to see and do. So do you have
It really is. And the proverbial Murphy to Manio is one, that drive is one that every statewide candidate, including me, has made, sometimes multiple times. Beautiful drive, but a lot of miles.
Yes, yes. Tell us about James G. Exum and why he's so important.
So I think he really is one of the most influential, maybe the most influential Chief Justice in the history of our court. The period I write about from 1986 to 1995, it was such a progressive era for the court. It really modernized North Carolina law in a way that it never had before. The court has always been, it's often described as a very conservative court. And as a result, it had been a little slower than most state high courts to embrace certain doctrinal changes that were going on in other states that other courts had adopted. And the Exum Court was really the first time that North Carolina took a long look at itself and what some of its neighbor state courts were doing and decided to integrate some of the doctrines that were finding favor in those other states. And that really just had not been done before in the history of our court. And that's why it really was such a special period. Jim Exum himself is such a fascinating figure. He, was born in the tiny town of Snow Hill in Greene County in eastern North Carolina. And he was a scholar, virtually from birth. He got a Morehead at Chapel Hill. Then he went to NYU Law School, and he thinks that maybe that's where he got some of the ideas that most North Carolina educated lawyers might not have been exposed to. But by being in a place like NYU that had a lot of professors who were maybe on the liberal side, on the progressive side, he was exposed to some ideas that he hadn't really thought about before, and he brought them back to North Carolina. And so I do think NYU Law School really does play a role in the Exum Court being what it was.
Mm-hmm. What were his core beliefs?
Well, he saw the law in very idealistic terms. He thought the law could accomplish good things for society. And, he makes no bones about the fact that he always had sympathy for the underdog, for the little guy, so to speak. And he wanted to make sure that their rights were fully protected against big corporations and against the government. And, historically, the North Carolina Supreme Court, some would say that really was not a focus of the court, that the court historically tended to rule with big business, with the government in criminal cases. But Exum was not afraid to shake things up. He really represented a new generation. When he first joined the court 11 years earlier, before he became Chief Justice, he was a full generation younger than the other members of the court. And he just brought just a different way of looking things. He looked different. One of his colleagues told him to get a haircut. He dressed differently. He was like the young upstart judge. And I think he was somewhat proud of that role.
With good reason. So there was a couple incidences, not incidents, but cases. One involved Singer Sewing Machine out of Lenore. And that was a woman who lost her job. And then tell us a little bit about that and why that was a record, a turnaround.
Yeah, you're talking about a case involving unemployment benefits. The law was a little bit in a state. I'm sorry?
Which is in our current news all the time now. So, yeah.
Absolutely. It's been about 3 years since I fully digested that case. And at the time I was writing the book, I certainly read it thoroughly. But it basically had to do with who had the burden of proof in showing an entitlement to unemployment benefits. Was it on the employer or was it on the employee? And the Exum Court tended to really favor the employee in disputes with their employers, which also had not been done much in North Carolina law. We have a doctrine in North Carolina called the Employment at Will Doctrine, which means if you are an employee without an employment contract, as most people are, your employer can fire you for any reason or no reason, obviously except based on race, religion, ethnicity, or gender. But otherwise, they can pretty much fire you anytime they want to. And that was the North Carolina Supreme Court had very solidly adhered to that doctrine over and over and over again. And then you had a case come up that I talk about in the book called Coleman versus Thomas Manufacturing Company, where a truck driver was fired because he refused to violate federal law by falsifying his travel logs. And his attorney just said to the Supreme Court, look, this isn't right. I'm not sure why, but there has to be some legal recourse. And for the first time ever, the North Carolina Supreme Court, the Exum Court, agreed and said, you know what, that's not right. And we're going to create a new doctrine, a new exception to the Employment at Will doctrine that keeps employers from doing this to employees. Nowadays, we sort of take that for granted. But when that case came out in the early 90s, that was a really big deal. It was the first time the North Carolina Supreme Court had ever said, well, there are limits to when you can fire an employee. So that one of many landmark cases decided by the court.
Yeah. Well, I think you did a great job. Perception, well, I already said that. In 1964, Sarah Parker was one of 8 women that was allowed into UNC Law School. That's not that long ago, right before we were born. And that just amazes me, that it was only 8 people there and she was finally allowed. Talk about her. She was such a trailblazer, you said, and what was
Absolutely. Sarah Parker is a true legend. She's one of the greatest judges North Carolina has ever produced. I mean, she literally has devoted her life to the law. And she has such an interesting background. She joined the Peace Corps and went to Turkey after graduating from college. Such a wonderful experience that must have been. Then she comes back to North Carolina. As you say, she's one of only 8 law students in her first year class. I think only 5 of them graduated, if I'm remembering correctly. Mm-hmm. Then she goes to Charlotte. She does a great job in private practice. Governor Hunt appoints her to the North Carolina Court of Appeals. And then she runs and gets on the court in 1992. And she never looks back. And she had such an amazing career, ultimately becoming Chief Justice, in 2006 until her retirement in 2014. I mean, she is one of those people that I just get chills when I'm around because I have so much respect for her. And sometimes it just dawns on me when I'm sitting in the courtroom that I'm sitting in a chair that she sat in, Justice Exum sat in, and some of these other luminaries that I write about sat in. It's just very, very humbling and just incredible.
Yeah. So you talk a little bit about all eight. You talk about Meyer, Mitchell, Lake, Parker, Fry, Webb, Wichard, and Martin. Were there anything when you were researching them that you found surprising? Because like I said, you made them real. Some of them were just farmers. And I'm not saying just farmers because that's a really hard, you have to be smart to do it. But
yeah, no, thank you for saying that. I really did want to get them off the pedestal and just show that judges are very, very real people. We are
yeah.
very, very human, and everybody has a backstory. And I just tried to point out some of the interesting aspects of their personality and background. But the most surprising thing to me, I say surprising, it's really one of the reasons I wrote the book. But I was so pleased that when I really got into it, that my premise was reinforced. That you had these 8 or 9 judges who all came from North Carolina. They all had similar backgrounds. They shared so many of the same demographic characteristics. All but one of them were Democrats. And yet, I mean, you would think that with that type of homogenous background, you would think that they would share the core beliefs about the role of judges and what courts should and should not do. And the reality was they didn't. This court was very, very divided in terms of judicial philosophy. On the one hand, you had Jim Exum, who as I say, was sort of the classic stereotype of the liberal judge. He wanted to make sure that criminal defendants were always treated fairly. He was not averse to overturning death sentences. In civil cases, he wanted to provide more remedies to injured employees and injured people in general. And on the other hand, you had Louis Meyer, who had the same background Exum did, but just came at the law in just a totally different way. He was very much a believer that policy-making decisions were strictly for the legislature, and the judges should never legislate from the bench, should never let sympathy play into their opinions, should never be result-oriented. And so even though he and Exum were best friends off the bench, they fought and fought and fought on the bench. And in opinions, they went back and forth at each other in a way that I just thought was fascinating. And I tried to quote from some of the more memorable decisions, particularly Justice Meyer's dissents. A lot of legal people who follow legal decisions think of Justice Scalia, the late Justice Scalia, as the master of the scathing dissent. Well, Justice Scalia had nothing on Louis Meyer, and I really try to quote some of the more colorful and memorable dissents from his career.
And you talk like that, but we have people in the same family that are brought up the same way that are completely different for their opinions too. But I do respect people who have an opinion, stick to it, and will fight for it. How do you feel about doing that with your opinions?
Well, we take this oath, and we take this when we become judges. We all put our hands on the Bible and take the oath to follow the law. And one of the things that's always fascinated me as a lawyer and still as a judge is how 2 judges, equally intelligent, equally hardworking, equally conscientious, equally trying to get the case decided correctly, can look at the prior precedents, can look at the facts presented in this case, and just reach totally, totally different conclusions. Mm-hmm. It's been happening ever since we had judges. So this is not a new phenomenon, but it still amazes me that happens, and it happens a lot. It's not rare to have a unanimous opinion, but it's not at all uncommon to have an opinion that's not unanimous, that has one or more dissents, one or more concurring opinions. And I just think that's one of the things that makes courts so interesting, that, people just read the same materials and just come away with different thoughts about how the case should be resolved. It's true on my court today. It was certainly true on the Exum Court, and it's really been true in courts for hundreds of years.
Which you would think, like, okay, people can look at art and have a different opinion, read the same book and have like a different take on it. But with the law, you'd think it would be a little bit more black and white. But
you would.
Yeah.
So part of the issue is when we're talking about the Supreme Court, by the time it comes to the Supreme Court, it's here for a reason. These are the hardest, the most complex cases in North Carolina, civil, criminal, and constitutional law. If they were easy cases, they wouldn't make their way to the Supreme Court. And because they're difficult cases, that sort of lends itself to split opinions, as we call them, in which different members of the court go different ways. But, the other thing, and not everybody realizes this, particularly non-lawyers, but some of the majestic provisions of our Constitution that we hold so dear are based on very, very broad phrases that courts have to put flesh on the bones, so to speak.
Yeah.
We talk about equal protection of the law and due process under the law. Those sound so powerful and inspiring and majestic, but what do they mean? What is due process? What is equal protection of the laws? In the First Amendment, Congress shall not make an establishment of religion. What is an establishment of religion? What is cruel and unusual punishment? All these phrases that we hold near and dear and take for granted, they're written so broadly in the Constitution, and they're not defined. And it's really been up to courts for these hundreds of years to put an actual literal meaning on these terms and define them in a way that they can be used to adjudicate actual disputes between litigants. That's one of the really fun and important things about being a judge, at least to me.
Yeah. So can you talk about the other people that were there? You talked about Meyer, you've talked about Parker, and what about Mitchell,
Sure.
Fry? Like, what made these people come together? Because sometimes you can have something that's so great that you need to hold it together, and things change after that. And I think that's what you try to capture here.
Well, it was. I call this a Mount Rushmore era of the court. It's just sort of a confluence of circumstances, some of it by accident, but you just happen to have 9 people who served in the 8 years of the Exum Court who were just all luminaries. Every one of them will live on and on in North Carolina legal circles. You mentioned Henry Fry. You can make a Hollywood movie out of Henry Fry's life. First African-American on the court, he grew up in segregated Richmond County in the 60s, tells a very poignant story about how on his wedding day, he was denied the right to vote by a white registrar who administered an impromptu literacy test in which he was asked to name everybody who signed the Declaration of Independence and all the ratifiers of the Constitution, a literacy test that none of us, certainly including myself, could have passed. But he never grew bitter. He was determined to succeed, and he did brilliantly. He was the only African-American member of his class at UNC Law School. He did a lot of great things in private practice. Then he went on the court, and he ultimately became Chief Justice. And just the nicest, most humble person you will ever meet. They all have great stories. Burly Mitchell ran away at age 16 to try to join the Marines. They found out how young he was, and they sent him back. And then a few years later, he joined up again and went to Southeast Asia and represented his country. Harry Martin grew up in the Depression. He worked as a musician before going to law school. John Webb practiced in FDR's law firm on Wall Street. They're all just such interesting people. And we're really lucky as a state that we had them, all these great minds and personalities on the court at the same time.
North Carolina politics are wild too, because we had Rufus Edmondson to the store, and he's a character, and he talks about politics back then too. And you touch on that a little bit. And then the Branch family has a book out too, talking about the Branch politics. So there's all of that encompassing, and your story is prolific too, because it encompasses all of that, not just their personal stories, but what was happening in North Carolina, why things changed, and you bring it back to maybe 1986 or even a couple of years before that with Reagan, and then things were just turning.
Yeah, I didn't really intend to write about this, but I got so into it when I was writing the book that I just could not help but devote the first section of the book to sort of the history of partisan judicial elections in North Carolina and how the Exum Court came to be. And, I talk in the book about how the Democratic Party really controlled all 3 branches of North Carolina's government during most of the 20th century, and particularly the judiciary, which is something I never knew growing up as a schoolboy in North Carolina. I just never knew that until I started working on this. As of 1986, when the Exum Court came to be, the last Republican elected to the court was elected in 1896. Think about that, 90 years earlier. Yeah, and that person was defeated in 1904, presumably because they were Republican. So you had sort of a de facto appointed system where Democratic governors would appoint Democratic members of the court who would retire shortly before they got to the mandatory 72-year retirement age, and then the process would repeat itself. But in the 1970s, for various reasons, a lot of southern states, including North Carolina, started becoming more of a two-party state in the legislative and executive branches. And 1972 was sort of a watershed year for Republicans in states like North Carolina. You had a Republican governor, you had Jim Holshouser, you had Jesse Helms win the first of his Senate terms, you had a pre-Watergate Richard Nixon carry the state. And then you get to 1984, another popular Republican, Jim Martin, is elected as governor. Jesse Helms wins a very bitterly divided U.S. Senate race over Jim Hunt. Ronald Reagan, another very popular Republican president. And then as governor, Jim Martin now, in his two terms, unlike Jim Holshouser, Governor Martin had the chance to make the Supreme Court a two-party court. And he appointed several Republican justices prior to the 1986 elections that officially gave rise to the Exum Court. And so for the 6-month period before the November 1986 elections, North Carolina had what it really had never had before, a partisan Supreme Court elections process. And I really try to write about that in the book because I just think it is so interesting, particularly for people, and you don't have to be a lawyer to appreciate it. Anybody who really enjoys reading about recent North Carolina history will hopefully find this interesting, but I just found it fascinating.
It is. So what do you think of politics now? Do you think things are changing? Like, it's not, when you and I were growing up in 1986, the year I graduated high school, and I remember, I mean, people weren't like Democrat or Republican in my book, but I don't know, it seems to be changing, and do you see that changing and going full circle again, back around, or like, how do we get together again? I have so many questions.
It's a great question. And I certainly do not claim to be an expert on these important issues, but like you, I am fascinated by them. I mean, it's no breaking news to say that we are probably more polarized than we've ever been, politically in your lifetime, in my lifetime, right?
Yeah.
I mean, there's always been some political polarization, but the level of discourse is just so toxic sometimes. It's really anything but civil. Again, not breaking news, but that really is what we have right now. And North Carolina has obviously become a true two-party state in all three branches of government, as I talk about in the book, as sort of the postscript to the Exum Court. During the 8 years of the Exum Court, all Democrats except Beverly Lake Jr. Joined the court for about half a year before Sarah Parker defeated him. So you go from having an all-Democrat Supreme Court as it had been for the last 90 years, and then by 1994, you had two Republicans run statewide for Supreme Court and win, and then in 1999, there was a majority of Republicans on the Supreme Court. And what really amazes me is by 2001, Sarah Parker, who we talked about earlier, was the only Democrat on the court. And you think about the last 90 years before that, and that really is amazing. But North Carolina is the ultimate purple state, and by 2016, Democrats had regained a majority on the court. So it just shows that North Carolina really is a purple state, and I don't think that's going to change. We're the state that had, of course, Jesse Helms and John Edwards as our two U.S. senators at the same time. How many states could say that?
Not many.
Or how many states could that happen in, I should say? Yeah.
So I talked to Andy Ellen, who is a lawyer who runs North Carolina Retail Merchants Association. He goes, you see all these politics and in the news and the newspapers, and it looks like we hate each other. He goes, but then we all play basketball together. We're all together. We're a community. Do you still see that going on behind the scenes?
I hope that's true. I really hope that's true. I was on the Court of Appeals for 6 years, been on this court for now a year and a half. So, I happen to be a registered Democrat, full disclosure, and I've worked with wonderful judges who happen to be registered Republicans and wonderful judges who happen to be registered Democrats. Yeah, it really doesn't matter. We really think of ourselves as independent. We're sort of forced by the legislature to run with party labels. They don't ask us, they just set the rules and we have to follow them. But we really don't think of ourselves as politicians. We don't think of each other as being members of one party or another. We sort of view ourselves as fellow soldiers in this common struggle, as it were, to find the truth, to apply the law fairly and impartially. And I hope that never changes, because that's a very special thing. You know, we have to be the one branch, particularly when there's this degree of political polarization in the other branches. We really have to be the one branch where all the politics is put aside and none of that matters. That's the way it has to be. That's why we have a judicial system, because we are supposed to not be bound to any person, to any political party, to any organization. You know, it's like we take our oath to follow the law, and that's what we all try to do.
I love that. I love that ideal. So when you were a kid, did the law interest you? Is this what you set out to do, is be a judge? Because 54, you're young to be a judge, don't you think?
Well, thank you. I don't get called young very often, so I appreciate that. You know, I always admire my colleagues on the bench who say, oh, yes, ever since the age of 6, I knew I wanted to be a lawyer, and I saw To Kill a Mockingbird. I have to confess, that really wasn't me. My biggest goal was to be point guard for the UNC basketball team, and that dream died when I was, I think, 7 years old. It wasn't until college when I just found myself getting interested in law, and it seemed to happen very gradually, and I switched majors a few times, and I ended up with political science. Which is not that there's a perfect pre-law major, but that's, a common major for people who are interested in law school, because, political theory, political thought sort of dovetails nicely into a legal education. But it really wasn't until college that I decided to embark on this path. And I'm very glad I did. It's been very rewarding.
Well, good. I'm glad to hear that. Is there a case that sticks out in your mind? You don't have to give us the details or the names. I don't know, you can't, but that's something that you never thought would happen, like a funny story, or, that one that you won't put down because it gets under your skin.
It's not funny. It's anything but funny, actually. It's a very sad case, but this is one that's always stuck with me. It's just one of the cases I really enjoyed working on as a judge. It was when I was on the Court of Appeals. Again, very sad facts. A teenage boy was sexually abused by a Catholic priest, and the boy's family, after all the criminal proceedings were done, they filed a lawsuit against the diocese, the church, a number of defendants, and claiming that they should have known this priest had tendencies to engage in this type of conduct, and that they should not let him be around children. And the defense that the church offered was based on the First Amendment, based on this notion that there are ecclesiastical matters that are beyond the purview of civil courts under the First Amendment. The idea being there's some religious doctrinal decisions that are made that civil courts just should not be allowed to adjudicate without running afoul of the free exercise clause of the First Amendment. And I just thought this was the most fascinating case. And I just spent so much time on it. And I worked so hard on writing an opinion, trying to get it right. And what we did in the opinion was we said that some of the claims that the boy's family were bringing were permissible. For example, negligent supervision, which is a common cause of action in North Carolina when an employer should be on notice that their employee is harassing or abusing subordinates, but doesn't take any action to stop it. So we said that type of claim could go forward because that really didn't require us to engage in religious doctrine. That was a secular doctrine that applied to any employer, church or otherwise. But there were other claims that the family had brought that really did cross the line into doctrine. For example, there were claims that the church should be held civilly liable because they had made this person a priest in the first place, and that they had not, I forget the name of the term, I'm blanking on that, but there is a term for taking away the status of priest to somebody who's engaged in misconduct. And they tried to hold the church liable for not going through that process with regard to the priest when they found out about his tendencies. And we held that those types of claims were off limits to us, that those were in fact claims that under the First Amendment, civil courts could not adjudicate under the First Amendment. We can't tell a church who to make a priest and who not to make a priest. We cannot tell a church who to remove from the priesthood and who not to remove from the priesthood. So it was a balanced opinion. I mean, I guess some would say we split the baby. Of course, we didn't think of it that way. But I found out later the case settled, and each of the two lawyers independently told me later how much they appreciated the opinion, how much they thought we got it right, and that the opinion had given them a roadmap to settle the case as amicably as a case like that can be settled. And that just made me feel good. I mean, that's when you feel like you're really doing your job, when both sides recognize that you're applying the law fairly and impartially and correctly.
Do you ever have conflict with your head? Like, okay, I know that this is what the law means, but like in a case like this with the priest, wouldn't you be like, oh, that makes me so sad? And no, he shouldn't be. Like, idealistically, you don't want that to happen. Do you have a hard time like in conflict with your head?
Well, I think all judges, have had situations where they have to reach a result because it's required by law that doesn't make them feel very good.
Yeah.
Sometimes we have to interpret laws that we don't always agree with. And, if a law crosses a constitutional line, of course, we have an obligation to declare it unconstitutional. But that's rare. I mean, most laws are within the legislature's purview and they are constitutional. And as human beings, we all have our own private beliefs, and judges all do. And we might, deep down, not particularly agree with the policy behind the law that we're being asked to apply, but we have to do it. I mean, you don't want a situation where judges get elected and just feel free to strike down laws they don't like and try to rewrite the laws as they see fit. That's really the opposite of what judges are supposed to do.
Yeah.
We're not supposed to be the policymaking branch. That's the legislative branch and to some extent the executive branch. We're supposed to be the ones in the middle who interpret the laws as written.
And I'm glad you're there doing that.
Oh, thank you. I appreciate it. It's a labor of love.
So is there, when you were writing this book, was there like a moral to the story that you were trying to convey to people? Or do you just want to get that story out because it was fascinating?
I think it's more the latter. I don't think it was so much of a moral. I just, there's so many books written about the U.S. Supreme Court, and deservedly so. The U.S. Supreme Court is one of the most fascinating institutions in American government, and clearly it's absolutely fascinating in so many respects. And I have read much more than my share of books about that court. But in North Carolina, and I've not done a survey of other states, but in North Carolina, there are very few books that have been written about the North Carolina Supreme Court and about the justices who have served on that court. There have been, a few, like the Susie Sharp biography was excellent. There's a biography of Henry Fry that's very good. There have been a few books like that, but not many. And it just seemed to me that this was a really important period for the court. And it just, to me, it had not, gotten the scholarly attention or the literary attention that it deserved. And it really made me feel good to bring this to people's bring this to light, and so people can read about it and learn about a recent chapter in our court's history that was just very, very influential, and that continues to change the law. All these landmark cases that I write about, it virtually every one of them is still the law of the land in North Carolina. So it wasn't like it was a one-time court that did something and then faded away. The legacy of the Exum Court continues to be with us.
Yes, I totally agree with you there. So if everybody's paying attention, right on the bottom in the middle of the screen is a buy the book button. And we can send out, we're going to get some copies to Mark and he'll be able to sign and we'll send them out for you. Does anybody have any questions at this time? Oh, we have one. What qualities do you believe Chief Exum possessed that allowed him to lead the NC version of the Warren Court? Seems that with many disparate views, judicial philosophies on the court, it would be like walking a tightrope. Do you recognize similar qualities in any of your current fellow justices?
What a great question. I have to think about that.
That would be my
second part. Very good question. Yeah. I appreciate that. Jim Exum is such an amazing person. He's very, very smart, but he also has a lot of book smart and common sense, as it were. Incredibly friendly, very persuasive, very charismatic. In North Carolina, the Chief Justice does not have quite as much power as the Chief Justice in the U.S. Supreme Court. For example, in the U.S. Supreme Court, the Chief Justice gets to assign opinions to individual members of the court to write. We don't do that in North Carolina. In North Carolina, we actually pick in a pre-assigned voting order after oral arguments. We pick the opinions we want to write. So the Chief Justice does not have that power. The Chief Justice has enormous responsibility running the judicial branch of government, which is the job in and of itself administratively. But as far as a member of the court, the Chief Justice is really just really first among equals, with an equal workload and no particular influence in how opinions are written. But given that, despite that, I should say, Jim Exum was able to use his charisma, his intelligence, his powers of persuasion to really influence his colleagues. Not Justice Meyer, who rarely went along with them, but Exum usually had a reliable voting majority, and he was usually in the majority in these cases that I write about in the book that are so important to the jurisprudence of the court. Because he was able to persuade his colleagues to go along with him. And Justice Meyer, conversely, felt very passionate about his own beliefs, but he wasn't quite as gifted as Justice Exum was in that area of getting people to go along with them. So those were some of the qualities that Chief Justice Exum had. As far as my colleagues on the court now, I think all of us look to Justice Exum as a hero, as somebody we admire, and I think we all try to emulate some of his wonderful qualities. But he really was one of a kind. There's just some people who come along who are just really special.
It's good to hear.
But thank you for the question. It's a great question.
Yeah. Do you have any advice for people who want to go into law school or want to be a judge?
Well, the best advice I can give to anybody, and this really is not limited to lawyers, but it's to go into a job that you're passionate about. In the law, particularly, it's a very, very time-intensive job. I mean, you're going to spend more hours with your colleagues than you are with your family. I mean, that's just a reality. You're going to work nights, you're going to work weekends. So if you don't love it, if you're not really passionate about what you do, you are absolutely going to be miserable. And there are some lawyers that I see, some I know very well, who are in these jobs that they don't like anymore to the extent they ever did. And it's very sad to me. The idea of Sunday afternoon and you've got that pit in your stomach because you're dreading going to work the next day. That's just an awful feeling that no one should ever do. Life is really too short. So that is my advice, to find a job that you're passionate about, that you not only don't mind spending long hours working, but that you actually enjoy spending long hours working because you are so passionate about it. I'm very lucky to have a job like that. My wife's a PhD in early childhood education, and she trains student teachers, and that's how she feels too. And we're both so lucky because there are so many people who don't love what they do. So, one thing about millennials is that I admire about them. Maybe our generation and older generations felt sort of an obligation to try to make a job work and stay with it throughout their entire career. But millennials don't seem to feel that way. And I think that's a good thing. I really do admire the fact that they want to be happy and they want to find a job that is fulfilling to them. And if that means having more than one job or two or three jobs during their career, they're okay with that. And I think that's a good thing.
I agree with you completely. Any other questions? Okay, remember that the buy the book button is there, and thank you all for tuning in. We're going to repost this on YouTube and all our social media. So thank you very much for tuning in. Thank you for the great question. And Mark, thank you. Much luck to you. Fingers crossed for a win in November. And thank you very much.
Thank you, Sue. I've had a wonderful time. I really appreciate you having me.
Yes, and honestly, I liked it. So
well, there you go.
Yeah, it was very, very good. And I appreciate you writing this and giving us a glimpse at what people do. So
much appreciated. Thank you so much.
Have
Thanks,
a great
everybody.
night. We have a comment there. Thanks so much, Justice Davis. This was great. Best of luck in November. So
thank you very much. I really